Schiff asked Bondi one question. She asked for a break. In 15 years of congressional hearings, you learn to read the room. You learn what a prepared witness looks like. You learn what a cornered one looks like. You learn the specific moment when someone sitting in that chair realizes that the question in front of them has no good answer and starts looking for a way out. Today, that moment came in the form of a recess request. Pam Bondi, the Attorney General of the United States, a former prosecutor herself, a woman who has spent decades in rooms where high-stakes questions get asked for a break, not at a natural pause in the hearing, not between rounds of questioning, right in the middle of Adam Schiff's 5 minutes, right after a single question landed in a way that nobody in that room was prepared for. This is what happened, and why that recess request may be the most telling moment of the entire hearing. Adam Schiff is not a surprise. Everyone in that room knew he was coming. His reputation as a meticulous, document-driven questioner is well established. His years on the Intelligence Committee gave him a specific kind of muscle memory, the ability to build a line of questioning around classified and sensitive material without ever crossing a line, while still making the implications of that material impossible to ignore. Bondi's team had prepared for him. You could see it in the early exchanges. When Schiff began his questioning, Bondi was measured, precise, and careful. She answered what she could. She redirected what she couldn't. She gave nothing away. For the first 2 minutes, it looked like a draw. Then Schiff changed direction. He had been asking about the DOJ's handling of a specific set of communications, internal correspondence between senior department officials that the committee had been attempting to obtain for months. The department had acknowledged the communications existed, they had not been produced. Bondi had explained the delay in general terms. Ongoing review, privileged considerations, the standard language that buys time in an oversight context without technically refusing compliance. Schiff had let her finish, then he set his notes aside. What he did next was not in the briefing Bondi's team had prepared for. He didn't ask about the communications themselves. He didn't press on the production timeline. He didn't reference any document or any specific date. He asked about a conversation, a specific private conversation between Bondi and a specific senior DOJ official on a specific date in a specific location that Schiff described in enough detail to make clear that he had a source inside the room where it happened. Attorney General Bondi, on the evening of February 19th, were you present for a meeting at the department with Deputy Attorney General and 2 senior officials from the Office of Legal Counsel, at which the production of the communications this committee has requested was specifically discussed? The room shifted, not because of what the question revealed, because of how specific it was. Congressional questions about meetings are usually vague. They're fishing expeditions, broad enough to catch something, but rarely precise enough to mean the witness is truly cornered. This question had a date, a location, a list of attendees, the kind of specificity that only comes from one of 2 places: documentary evidence or a first-hand account from someone who was in that room. Bondi looked at her counsel. Her counsel leaned in immediately. A whispered exchange that ran longer than any previous consultation in the hearing, long enough for the cameras to catch it, long enough for the room to feel it. Then Bondi looked back at Schiff. "Congressman, I'd like to request a brief recess before responding to that question." The room did not erupt. It absorbed. Because everyone in that room, every committee member, every staffer, every reporter, every legal observer, understood what had just happened. Witnesses don't request recesses in the middle of questioning because the question is complicated. They request recesses because the question is dangerous. Because the answer, given without preparation and without counsel's full input, could create a problem that is worse than the question itself. In 30 years of congressional oversight history, recess requests mid-questioning are vanishingly rare. They happen when a witness is confronted with something they did not expect and cannot safely answer in real time. Bondi had not expected this question, and she could not safely answer it in real time. The committee chair granted a 10-minute recess. Standard procedure, no drama in the granting of it, but in those 10 minutes, the story of the hearing changed. Because the recess request itself, regardless of what Bondi said when questioning resumed, had told the committee something critical. The meeting Schiff described was real. If it weren't, Bondi would have denied it immediately. A false premise is the easiest thing in the world to deflect in a congressional hearing. You simply say, "That meeting didn't happen, Congressman, and I'd like to know where you're getting your information." She didn't say that. She asked for 10 minutes, which means the meeting happened, which means Schiff has a source, which means the internal deliberations about withholding these communications from the committee were documented or witnessed by someone who is now talking. When questioning resumed, Bondi was more careful, more guarded. The fluency that had characterized her earlier answers was replaced by something more deliberate. She confirmed that she had been present for internal discussions about the committee's document requests. She said those discussions were privileged. She said the specifics of any internal deliberations were protected by executive privilege and attorney-client considerations that the department was prepared to assert formally if necessary. Schiff listened. Then he asked the follow-up. Attorney General, executive privilege protects deliberations about policy. It does not protect deliberations about compliance with a congressional subpoena. Are you asserting that the department's internal discussions about producing documents to this committee are shielded from oversight by this committee? A long pause. The department's legal team is prepared to provide a formal privilege log identifying any materials for which privilege is being asserted. That's not what I asked. Another pause. I understand your question, Congressman. I'm telling you the department's position. Schiff looked at the camera, then back at Bondi. The committee will respond to that position formally. I yield back. 2 exchanges, 1 recess request, and a hearing that just became significantly more serious, because Schiff's follow-up question did something that will matter enormously in what comes next. It drew a direct line between executive privilege, a legitimate legal doctrine with defined boundaries, and obstruction of congressional oversight, which is not protected by any privilege. The department cannot claim privilege over its own deliberations about whether to comply with a congressional subpoena. That is not what executive privilege covers. And Schiff, who has spent years litigating exactly these questions in exactly these contexts, knows that by asking the question on the record and by receiving an answer that neither confirmed nor denied the privilege assertion, he has now created the foundation for a formal legal challenge. The committee can now go to court, not to get the documents, not yet, to establish that the privilege assertion itself is invalid, to get a ruling that the internal discussions about document production are not protected, and then, with that ruling in hand, to demand the documents and the communications and the full record of every conversation that happened in that room on February 19th. Pam Bondi has been in difficult legal positions before. She knows how these fights unfold. She knows that a congressional oversight dispute can drag on for months, that privilege fights are slow and expensive and uncertain, that the political calendar can shift faster than the legal one. What she may not have fully accounted for is Adam Schiff's patience. He has been in this fight before. The document battles, the privilege assertions, the recess requests, and the formal responses, and the slow, grinding work of building a record strong enough to support what comes next. He built that record today, 1 question at a time, and the recess request, 10 minutes, mid-questioning, caught on camera, noted by every observer in that room, is now part of it. Schiff asked 1 question, a specific question, with a date, a location, and a list of names. The kind of question that only gets asked when the person asking it already knows the answer. And Pam Bondi, the Attorney General of the United States, a former prosecutor, a veteran of high-stakes legal confrontation, asked for a break, not because she needed time to think, because she needed time to figure out how much Schiff already knew. The answer to that question, what Schiff knows, where he got it, and what he does with it next, is what this investigation is now about. And the hearing today made clear he knows more than Bondi was ready for.